transcript of my jury instruction. And there's also a transcript of my sentencing proceeding in the same booklet. And let's get to that, because I thought you might ask me this, so I looked at these notes yesterday, and now the funny thing about jury instructions is that they're divided into two sections. The first section is what we colloquially call boilerplate. In other words, it's general instructions that apply to every criminal case, the burden of proof, the standard of proof, etc. And then we get into what we call the specific instructions as to the crimes themselves and as to the defenses that are then presented and the jury has to know about it. Now, as you'll recall, there were two different defenses presented in this case. The first one was a defense called extreme emotional disturbance. And this is a rather unique defense under New York criminal law. It is not a defense that shows lack of criminal responsibility, such as the insanity defense, but it's a mitigating defense. In other words, a jury may decide that a homicide occurred because of extreme emotional disturbance, but they can't let the guy off. In other words, all they can do is reduce it to the manslaughter below the murder charge. So I gave the jury an extensive instruction as to the extreme emotional disturbance defense. And I don't know whether you want me to read it or not.
That would be great.
Okay. All right, ladies and gentlemen, the defendant, Ronald DeFeo, Jr., has raised upon his trial what is known as the defense of extreme emotional disturbance. I want to clarify at this point that I'm talking about is now a defense entirely and separate and distinct from another defense, which I will discuss in a few minutes, the defense of legal insanity. I'm now talking about an entirely separate and distinct defense. The law provides that in any prosecution of a defendant for the crime of murder in the second degree, that is, the intentional killing of another person, the jury may reduce the crime of murder to a conviction of the lesser degree of homicide, known as manslaughter in the first degree, if the jury finds that when the defendant intentionally killed, he acted under the influence of extreme emotional disturbance for which there was a reasonable explanation or cause. In other words, the law permits a jury to take into consideration as a mitigating circumstance the fact that a homicide was committed by a defendant under the influence of extreme emotional disturbance, and to find such person guilty of manslaughter in the first degree instead of murder in the second degree. The law further provides that a jury, in determining the reasonableness of a defendant's explanation or excuse, must measure the reasonableness of a defendant's explanation or excuse from the viewpoint of a person in the defendant's situation under the circumstances as the defendant believed them to be. In other words, the reasonableness of the defendant's explanation or excuse must be looked at from the viewpoint of a person in the same situation. Now, applying the law that I have just given to you to this particular case, whether or not the defendant, Ronald DeFeo, Jr., is intentionally killing any or all of the 6 members of his family, acted under the influence of extreme emotional disturbance, is a question of fact for the jury to decide based on all the evidence in the case. If you find from the evidence that at the time the defendant killed any particular person, he was acting under the influence of extreme emotional disturbance, and there was a reasonable explanation or excuse for such extreme emotional disturbance, then you may, if you choose, reduce the crime of murder to a verdict of guilty of manslaughter in the first degree. Now, that's basically the legal explanation, and now I refer to what I call the contentions of the parties. The defendant, Ronald DeFeo, Jr., contends or claims that the evidence on this trial shows that he did act under the influence of extreme emotional disturbance for which there was a reasonable explanation or excuse. The prosecution contends that all the evidence in the case shows that the defendant was not acting under the influence of extreme emotional disturbance when he killed each of the family members. The people contend that the defendant's conduct and actions as he shot the victims were deliberate, calm, callous, without feeling, unfrenzied, and uninfluenced by extreme emotional disturbance. The people claim that there is no evidence in the case that the killings were sudden, passionate acts triggered by extreme emotional situation. The prosecution contends, therefore, that they have disproved any claim of the defendants having killed under the influence of extreme emotional disturbance. Now, that was my instruction to the jury on that defense. Now we go to the main thing. This brings me to the law regarding another defense which has been raised in this case, and I'm now referring to what is known as the defense of mental disease or defect. The defendant, Ronald DeFeo Jr., has raised upon this trial what is known as a defense involving lack of criminal responsibility. In particular, the defendant has raised what is known as the defense of mental disease or defect. Now, this defense is more commonly referred to as the defense of legal insanity, and for the purposes of clarity, I will hereafter refer to this defense in those terms rather than using the formal legal name of the defense. Legal insanity is a complete defense under the law. A person who is legally insane, as the law defines that condition, is considered incapable of committing a crime and not criminally responsible for his conduct. The defendant has raised this defense by presenting evidence in support of his claim that on November 13, 1974, he lacked criminal responsibility for the killings by reason of his legal insanity. The law provides that when the defense of legal insanity is raised by a defendant upon trial, the people or prosecution have the burden of disproving such defense beyond a reasonable doubt. Now, interrupt a moment. That was the law at the time of the trial. The law in the state of New York now has been changed. Now, the burden of proving legal insanity is on the defendant, but at the time this law was enacted, the burden was on the prosecution to disprove it. Now, applying that principle to this case, in that the defendant, DeFeo, has raised the defense, the people must establish on the whole case, to the jury's satisfaction beyond a reasonable doubt, that the defendant on November 13, 1974, did not lack criminal responsibility for the killings by reason of legal insanity. The particular law in regard to this defense is set forth in Section 30.05 of the New York State Penal Law, the applicable language of which reads as follows, quote, "A person is not criminally responsible for conduct if, at the time of such conduct, as a result of mental disease or defect, he lacks substantial capacity to know or appreciate either A, the nature and consequence of such conduct, or B, that such conduct was wrong." Now, the common law of the state of New York contains the presumption that every person is presumed to be sane and to possess sufficient degree of mental capacity to be held responsible for his criminal acts until the contrary is shown. In the state of New York, the legal test for lack of criminal responsibility by reason of legal insanity is specifically defined and set forth in the statute I have just read to you. And this, ladies and gentlemen, is the test that you must apply to the evidence in this case. You must not use any idea or concepts that you have of legal insanity other than the definition set forth in the New York statute. And then I went on in a great deal of an explanation to say what the various terms in the statute were. Now, I then, after I went through that explanation of the jury, I then explained to the jury what the contentions were of the parties in the case. And what I said at that point, I will now recount to you what I see to be the claims of the parties as to this particular defense. The defendant, Ronald DeFeo Jr., claims that on November 13, 1974, he was suffering from a mental disease known as paranoid psychosis, or paranoid state, and that as a result of this disease, he lacked substantial capacity to know or appreciate that his conduct in shooting and killing the 6 members of his family was wrong. The defendant claims that prior to November 13, 1974, he began to have paranoid delusions by which he believed that many people were going to kill him and that he must kill them first. That such delusions became uppermost in his mind and became fixed first upon his father and then upon the other members of his family. That matters came to a head on the night of November 12, 13, 1974, when, after watching a World War II movie on television, he, in a psychotic state of mind, then shot and killed the 6 members of his family whom he believed intended to kill him. That because of his paranoid belief as to having to kill his family, he did not know the wrongfulness of killing them and believed that the imminent danger to himself justified his conduct. The people of prosecution claimed that on November 13, 1974, the defendant, Ronald DeFeo, Jr., was not suffering from the mental disease known as paranoid psychosis. The people claim that the defendant did have substantial mental capacity to know and appreciate both the nature and consequences of his conduct, and that his conduct was wrong. The people claim that the defendant was not psychotic at the time of the crime, but was rather suffering from a condition known as antisocial personality, a type of mental disorder which is much less severe than a psychosis. The people claim that the defendant's antisocial personality did not deprive him of the mental capacity to know and appreciate the wrongfulness of the 6 killings. The people claim that the defendant fully knew and appreciated that the killing of his family members was wrong, both in the legal and moral sense. The people claim that the defendant has feigned and fabricated mental disease in an attempt to escape criminal responsibility for his acts. The people claim, upon all the evidence in the case, that they have disproved the defense of legal insanity beyond a reasonable doubt. The defendant claims that the people have not disproved his defense of legal insanity and that there exists reasonable doubt as to the defendant's legal insanity at the time of the commission of the crime. Now, that was basically my jury instruction as to both defenses that were raised. And I try in my jury instructions to take legal concepts and try to convert them into language that is understood by lay people. It's a very difficult thing to do.
Now, what were their options? Could they have found? They obviously couldn't find for mental defect and insanity both.
No, they were told in the final instruction as to their options of the verdicts on each count.
That's what I'm interested in hearing.
Yeah.
What were their options?